This week, it was reported that special counsel Jack Smith is requesting that the judge in the case involving Donald Trump's documents grant permission for the crime-fraud exception to be included in some of the attorney-client privileges or the common interest privilege, which is a type of umbrella privilege. Former federal prosecutor Harry Litman pointed out that the Trump lawyers are likely to be in trouble and will likely be required to testify before the grand jury. National security lawyer Brandon Van Grack said, "These are the final steps in the investigation," in response to the previous New York Times report on the privilege argument. A few weeks after Chief Judge Howell ruled that Mueller could use the crime-fraud exception, Manafort was indicted. Once C.J. Howell makes a decision on this, it shouldn't take long for a decision on the charges. "We're pretty far down the line of the investigation," Litman acknowledged to MSNBC. "The focus is not on Evan Cochran and Christina Bobb, I think that's the headline," Litman stated. "They lied about the subpoena, which is blatant obstruction, which is what happened here. They brought Cochran before a grand jury and wanted to know if there was possibly fraud in the communications between Trump and Cochran. There is evidence that is independent of all of this. They inquire, 'What did Trump say to you?' He responds, 'Well, due to attorney-client privilege, I refuse to answer.' 'Fine, see you in court,' Smith says. You compared it to the aggressive move that Robert Mueller would not make up top. Additionally, it has Trump, and Trump alone, in its sights." Smith's actions over the past few weeks have been characterized as an increase in seriousness or aggressive tactics, according to the Times and other commentators. The Dodge's actions appear more hostile than they have in the past because the reporting suggests that Smith may be nearing the end of the investigation. Unless Cochran decided to fall on his sword and grant Trump total deniability, which is possible, but man, you don't find that very often. The question is what the communications from Trump were, and were they, as you suggest? Thus, Trump is a part of this decision. Trump's words to him could be very strong proof of obstruction. One quick point about procedure. The government only needs to present a small amount of evidence that there may be evidence of a crime. The judge, Beryl Howell, will then decide if that's enough to break the exception. Nichol Wallace, a host on MSNBC, said that the stolen White House documents have been the subject of numerous obstructions of justice since February 2021. "The FBI knew exactly where everything was, so we know there was stuff everywhere," Wallace stated. "We are aware that Donald Trump obstructed the Mar-a-Lago investigation into classified documents." Litman concurred, "Everything you say is correct. And don't fool yourself into thinking that you've doubled your legal education in the past few years. But there's one thing we don't know, and it could be a killer piece of evidence. Before you signed that document stating that we had diligently searched and found everything, what did Trump tell you? One piece of evidence that Smith lacks if the real response is that he was not involved if, on the other hand, the statement he said just tell him this, I don't care is true or false. In front of the jury, you now have a fantastic piece of evidence that came from the lawyer. We don't know anything about that particular piece yet, but it could be deadly." Frank Figliuzzi, a former counterintelligence assistant director for the FBI, stated that based on his observations of the case, it is evident that the Dodge is nailing it down tight. Figliuzzi stated that the obstruction case is solid, despite the fact that other aspects of the case raise questions. He stated that it is not necessary to demonstrate the lawyer's involvement in a crime, but the court's language indicated that the actions were in furtherance of a crime. He recalled, "I go back 23 years to my days in Miami, where we had lawyers being paid in suitcases full of drug cash, and yes, we were debating about going into lawyers' offices. That's very interesting to me. Again, it frequently necessitates high levels, and I'm confident that if Jack Smith is engaging in this activity, he will have someone speaking beyond what we described regarding the videotape and individuals moving boxes following the subpoena. The ultimate dilemma for a defense attorney, I believe, is having to provide evidence against their client, but now it's up to them to decide whether they prefer their career and bar license or freedom. They are going through a lot right